And today we're joined by Professor Monet, who comes to us from the Mailman School of Public Health at Columbia University. And where she directs the program on migration and public health. And Professor Zad is an expert on the issue that we'll be discussing today, which is international migration, really. And for those of you who have followed it, Professor Tom Farah, who used to chair the Inter-American Commission on Human Rights, has described international migration as the future, the immediate future of US democracy. He says it is that serious that migration holds the key to US democracy. Across the pond on the European Union side, a lot of people suggest that migration is going to make or break the European Union. And for those of you who are interested in football, apparently migration is also about to make or break the BBC. As some of you may have noticed, the BBC's programs for last weekend all crashed after a famous former footballer who anchors its weekend sports program issued a now infamous tweet about the migration policies of the conservative government in the United Kingdom. His name is Gary Lineker, who used to captain the England's national football team. And if you are to believe much of Western media, migration also holds the key to the future of lots of young people from other parts of the world, including Latin America, parts of Asia, and certainly Africa. So that says that the future for the next about 15 minutes or thereabouts is in the hands and mouth of Professor Zad here. And for this, this is a graduate studies class, LLM, and model students for the most part, and we're joined by faculty as well. And particularly, it's my pleasure to welcome Professor Pazatis, who holds the Karamanlis chair here, but also currently chairs the Human Rights Committee under the Post-Optional Protocol. And before that, actually, was the vice chair of the Human Rights Committee. So she's seen it all at that level. And please join me in welcoming Professor Zad as I hand over. Thank you.
In my hands, no pressure there or anything. But, thank you all for this kind introduction and for having me here today. It's a beautiful campus. I'm very envious as someone who teaches in a very, very urban space. Having some sunlight and blue sky that is just peeking out is very nice to see. So, you know, in my remarks this afternoon, I'd like to discuss one of the sort of increasingly prominent phenomenon in the international migration space, which is the issue of externalizing migration control by states and the implications of this accelerating practice for the rights and protections of refugees and migrants alike. So after a few words of background, what I propose to do is to cover three things in my remarks today. First of all, just spending a few minutes describing what externalization is and some of the ways in which it is practiced. Second, I hope to look at some of the rights implications of these practices. And third, perhaps to suggest some things we can do about it as lawyers, as activists, as scholars, and then hopefully open up the space for discussion. So, just by way of introduction then, obviously the 1951 UN Refugee Convention, adopted in the aftermath of the Second World War and the horrors of the Holocaust, and the various regional refugee rights instruments that have been adopted since then, really embody the idea that those who flee conflict and persecution should be able to find safety and protection in countries of asylum. And today that protection is needed more than ever. The UNHCR estimates that by 2022, there were 103 million displaced people, of which about 37 million were refugees and asylum seekers, and approximately half internally displaced. Syrian refugees still account for the largest single group of refugees in the world today at around 6.6 million, followed by Venezuelans, Ukrainians, Afghans, and refugees from South Sudan. It must be said that the vast majority of forcibly displaced populations continue to be hosted in low and middle income countries, around 83%. And this is even when you take into account the numbers from Ukraine being hosted in the European Union. In what was an atypical and laudable response to that particular crisis. But against this backdrop of sort of unprecedented human mobility, at least in human memory, states largely in the global north have spent an extraordinary amount of their time really trying to deflect and shift their protection responsibility onto other countries by blocking and impeding the access of migrants and asylum seekers to their territory, which is of course fundamental to the right to claim asylum. These measures cumulatively push asylum seekers and migrants alike onto ever more dangerous routes with grave consequences in terms of the risks of death or serious injury for the migrants themselves. And these new and rapidly evolving transnational mechanisms of externalized migration control are increasingly elaborate. And if we are to hold states accountable to their international obligations and to safeguard the principles of refugee protection, alongside things like the right to life, fundamental rights to life, rights to health, and so on, we really need to retool the way we think about jurisdiction and state responsibility in order to address them. We also need to rethink the way we approach our legal and policy advocacy so that we are more transnational, comprehensive, and effective in our approach. So let's begin with what is externalization. And I think it's notable that there is no set definition yet, and I think it's a term being used in a multitude of different ways. It's a term that is used broadly to describe migration control measures taken either unilaterally or multilaterally by states that affect the ability of refugees to seek asylum and shift protection responsibilities for people seeking asylum outside the territory of the state. These policies and techniques range from direct interdiction and prevention to more indirect policies that work through third countries, often and increasingly using development aid to prevent migrants, including asylum seekers, from ever reaching destination states and triggering their asylum obligations. Now, the recently released Refugee Law Initiative Declaration on Externalization and Asylum has tried to provide a little bit more clarity in this space, and it defines externalization as the process of shifting functions that are normally undertaken by a state within its own territory so that they take place in whole or in part outside of its territory. And the declaration and the background commentary on it distinguishes between externalized border controls, which include practices of pushbacks, and externalized asylum systems, such as offshore models to consider asylum applications. Now, the process of externalizing borders really took off in the 1980s. It was modeled by the US with its interdictions of Haitians at sea, and the use of Guantanamo to warehouse migrants and asylum seekers long before it became synonymous with terrorism. Australia piloted its own Pacific solution in which arrivals were held effectively indefinitely in offshore island detention centers in places like Nauru or Papua New Guinea off the Australian mainland. And today it sort of moved on to just pure pushbacks in cooperation with Indonesia and Malaysia, countries like Indonesia that aren't even signatories to the 51 Refugee Convention. Europe on its eastern border has its 2016 EU-Turkey Action Plan, which returns to Turkey asylum seekers and irregular migrants crossing to Greece. On its southern border, Europe has effectively pushed out its border to Niger, Libya, and Sudan through an elaborate layer of security, migration management, and development cooperation agreements. So, for example, the 2016 EU-Africa Action Plan, whereby Europe agreed to offer training and support to law enforcement and judicial authorities in the name of combating trafficking and smuggling. And this agreement was used as the basis for sending cameras, scanners, servers to Sudan when it was under the regime of Omar Bashir. And this equipment would be used to register refugees, to train Sudanese border police, and to construct 2 closed camps with detention room for migrants. And it's important to note that all of this was taking place under the leadership of the German Development Agency, spaces that we don't normally think of when we begin to sort of unpack our refugee advocacy and our migration strategies. So, obviously Sudan is and was important to Europe at the time because it is a central transit point for refugees coming from Eritrea, from DRC, from Central African Republic, Somalia, not to mention, of course, Sudanese themselves. And they would travel through en route to Libya and eventually make it for a possible Mediterranean crossing. Niger alone, the last time I checked, was the recipient of over $1 billion of European Union development aid, most of which is channeled into anti-migration policies. In return, it has suspended the ECOWAS Free Movement of Persons Protocol in the region north of Agadez. And in 2015, it adopted its anti-trafficking law, which has been the basis for the crackdown on smugglers and migrants. And of course, even here in the US, even prior to the pandemic, when the Trump administration wasn't distracting us with the wall, it was introducing far more insidious administrative barriers to asylum in the form of metering, the so-called migrant protection protocols, also known as Remain in Mexico, and attempting to negotiate safe third country agreements with Guatemala, El Salvador, and Honduras, all of which, again, have the effect of pushing migrants and asylum seekers back to Mexico and beyond. And many of these same policies are either being continued, discussed, or in fact intensified by the Biden administration. So today in the US, layered onto the Title 42 public health expulsion order, which effectively during the pandemic closed the border to migrants and asylum seekers and held them in place in Mexico. So layered onto Title 42, which we have with us until May, you now have a system of discretionary exceptions being made. Initially, those exceptions were made for vulnerable individuals, and now they're sort of nationality-based exceptions for who's allowed in. So to start with, you had individuals from countries other than Mexico, Guatemala, Honduras, El Salvador, and now Venezuela, who were largely waived in because Mexico wouldn't allow the Biden administration to send them back. Ukrainians have now been allowed in and given an exception to Title 42. And what we sort of see happening before us is really the reshaping of our asylum regime from one that is based on rights and principle and due process to essentially one that is discretionary, highly politicized, and nationality-based, where we pick and choose which asylum seekers we want to admit to the US. So women, children, unaccompanied minors, yes. Single men, absolutely not. Single women, probably not. Yes to Ukrainians, no to Haitians. And I think the racial underpinnings of what we see evolving are stark and profoundly disturbing. And I find it shocking, to be honest, that we're not more aware of how fundamentally the Biden administration is reshaping what is and what is not acceptable rights and asylum practice. And in May of this year, Title 42 is due to be lifted, and what will likely replace it very much draws on the externalization playbook. So the proposed rule that we have before us at the moment would essentially operate like Trump's transit ban and bar asylum for any person who had not previously applied for asylum in a third country before reaching the United States, as well as barring asylum for those who present themselves between ports of entry or even at a port of entry, but without an interview that they have to schedule in advance using an app called CBP1, which you may have heard of. CBP1, of course, presumes that migrants sitting in Mexico will have access to phones, will have access to data. And of course, all apps can be glitchy. CBP1 is profoundly glitchy, intentionally so, I think, and very restrictive in the interview slots that it grants. And we already, I think you may have seen earlier this week, saw a group of migrants storm a port of entry, the US port of entry, in part because of frustrations at the use of this app. And we're working with Jesuit Refugee Services in Mexico on a project. And, they're describing how unfair and problematic this new technology is operating. In any case, I think it's worth recalling that under international law, and in fact, US domestic law, refugees may not be penalized for unlawful arrival or presence. And that's actually a fundamental protection to ensure that the principle of non-refoulement actually has some teeth. The most recent iteration of this practice, of course, is the UK-Rwanda deal, whereby asylum seekers arriving by boat in the UK would be relocated to Rwanda, a country with its own decidedly patchy record of human rights compliance. And they'd be sent to Rwanda not for offshore processing with the hope of eventually, sort of having the UK as a permanent destination, but for Rwanda as a permanent destination for them. And I think as commentators at the Migration Policy Institute have noted, not only does this gut the concept of territorial asylum, but it really represents the zenith of a system that is not based on principle, but that is essentially transactional. So let's not even bother couching it in development aid. The UK will essentially pay Rwanda to take on the UK's asylum obligations under the 1951 Refugee Convention. So that's really where we are today. So I'd like to move on to the second part of my remarks and the rights implications of some of these practices. At a minimum, all of these attempts to deflect asylum seekers and migrants raise very real risks that refoulement will happen and that people will be forced back to places where they might face persecution and where their lives might be at risk. And second, while these measures may slow migration, and certainly both in Europe and the US, governments love to tout the results in terms of the numbers that have decreased, the numbers of encounters that have decreased because of these investments. But what ends up happening is they ultimately push migrants and asylum seekers alike onto increasingly clandestine and dangerous routes, alongside, sort of refugees, migrants, asylum seekers, all on the same routes, trying to reach countries of destination and facing magnified risks of death and injury. And so, I also think, by the way, that, these short-term drops that we often see in the numbers, for example, the Biden administration saying now, look at the fact that we've introduced some of these new measures has led to a radical drop-off in the numbers of encounters, actually don't bear out over the long term. And so, the number of sea crossings that we're seeing in Europe on the Mediterranean have been going up, certainly post-pandemic. And I think, it's important to sort of challenge those assumptions over time. But in any case, back to these increasing dangers that migrants and refugees now have to encounter. Of course, there's the right to life, which is foundational for all human beings, whether they're migrants, asylum seekers, stateless, or citizens. And not a day seems to go by without us, hearing of migrants either perishing at sea, suffocating in overcrowded trucks or buses. And the IOM's Missing Migrants Project, which has been in operation since 2014, has recorded more than 50,000 deaths since then, although this is, I think, most certainly an undercount. And half of those that have been counted have occurred within or en route to Europe. Now, it must be said, states do not regularly collect, report, or share data on migrant deaths. And the quality of the data that we have is patchy at best. For example, although we know that migrant women and children face greater risks while in transit, the data that we have is not regularly disaggregated by sex, age, or country of origin. And a 2017 UNICEF study found that nearly half of the migrant women and children who had been surveyed in Syria reported sexual violence and abuse on their journey, often at multiple points and multiple locations. Now, in a seminal report in 2017, Agnes Kalamar, who's now Secretary General of Amnesty International, was then the Special Rapporteur on extrajudicial summary and arbitrary executions, noted the following, and I'm going to bear with me while I read this out. I rarely do it, but I think what she has to say is so profound. She says, This human rights and humanitarian crisis is characterized by mass casualties globally, a regime of impunity for its perpetrators, and an overall tolerance for its fatalities. An international crime whose very banality in the eyes of so many makes its tragedy particularly grave and disturbing. Its victims are refugees and migrants. Data on their arbitrary deprivation of life are still lacking or vastly inaccurate, making for a macabre balance sheet that tells us too little, too late. The data don't tell us the manner of these deaths, how many people have been executed, shot, or drowned, how many have lost their lives to starvation or dehydration, how many have been tortured, denied life-saving treatment, or have died from despair. The figures tell us little about the perpetrators of these violations against people forced to flee their homes and countries, be they security officials, armed groups, or smugglers. And the data don't reveal how state policies may be responsible for violence and abuse. And I have to say, I see this report as being a sort of a clarion call for action. She's basically saying there is state complicity here, people. We need to hold states accountable. And again, I don't know whether it's because of the complexity or because of the invisible nature of this crime, but relatively little being done in response. I think compounding the dangers that migrants are facing en route is that governments, in particular European governments, led now by Italy and the new far-right leadership of Giorgia Meloni, have also systematically been constraining the ability of NGOs and humanitarian rescue ships from operating in the Mediterranean through a barrage of legal threats and bureaucratic obstacles that are intended to harass and intimidate aid workers. And this year, again, I'm sure you all saw it, there was a very high-profile trial in January of 24 members and volunteers with a Greek NGO called the Emergency Response Center International, ECRI, which helped more than 1,000 people to reach safety and provided survivors with medical or other assistance on the Greek island of Lesbos between 2016 to 2018. Now, these 24 volunteers found themselves charged with people smuggling, as well as money laundering, espionage, and membership in a criminal organization by the Greek state. ECRI has been forced to close its operations, and the defendants spent 4 years waiting for their trial to happen. Eventually justice was served. The charges were all dismissed on procedural grounds, it must be said. But you can imagine what a chilling effect this has had on migrant rescue and the NGOs that work in this space. The UN Human Rights Office, UNOHCHR, has noted its long-standing concern that anti-smuggling legislation in a number of European countries is increasingly being used to criminalize both migrants as well as those who assist them. Now, beyond NGOs and sort of rescue operations, commentator Elspeth Gilders also speculated that the risks for migrants are compounded further because smaller fishing and commercial vessels also simply just don't want to take the risk of sort of honoring that time-honored tradition of rescue at sea. And she also points to the role of EU anti-smuggling and trafficking legislation and the way it has been transposed into national law, saying that it creates a presumption that captains who do rescue people commit the offense of smuggling or trafficking if they end up bringing those unauthorized people into harbor. Consequences they face are criminal prosecution and confiscation of their boats. And while, captains can say and will eventually be excused if if they can prove that they were acting out of humanitarian motives, the reality is this process takes years. They may lose their livelihoods and they'll lose their source of income as a result while they're waiting for their trial to occur. So all of this is really using the bureaucracy of the anti-smuggling and anti-trafficking framework to really impinge on, good old-fashioned humanitarian work. And of course, the US isn't to be left behind. There's also been attempts to prosecute NGO volunteers in the US, thankfully not successfully with the group No More Deaths that were working in the Sonoran Desert. But again, the fact that we even have to launch defenses for humanitarian aid workers doing this kind of work is really troubling. And I have to say, the ultimate irony for me is that states increasingly dress up these efforts, these externalization efforts, and the sort of accompanying anti-smuggling and anti-trafficking work that they're doing in the language of protection. They're using the language of protection to say, well, we're doing this to stop migrants from making a dangerous journey. We're doing this to stop migrants being lured by traffickers. Or they're using, as I explained earlier, the language of development cooperation to sort of really, I think, mask what it is that is happening. And I do think that the trafficking rhetoric is particularly insidious in this respect, because it's those very same policies that have fueled the market for human smuggling. And I really fear that advocacy and advocates often just walk into this trap that states have laid for us by essentially being co-opted by the trafficking framework. I know I can be challenged on this, so feel free to challenge me later. So what do we do about this? How am I doing on time? Am I okay?
Yeah.
All right. So I'll try and be quick. So what do we do about this? I mean, I think first, we need advocacy to say that saving lives is not a crime, obviously. Second, I think it's really crucial to use the law as creatively as we can to hold states accountable for deaths and human suffering that their policies are causing. But of course, then the question arises, which states do we hold accountable? So through externalization, countries of the global north are clearly trying to insulate themselves from legal liability and shift their legal responsibilities onto third countries that often have far fewer resources in practice. But when rights violations occur, as is almost inevitable, there are these complex issues of state responsibility that we need to unpack. And this is where we need, frankly, good human rights lawyering, because we need to push beyond the conception of jurisdiction as being tied to territorial control. Now, the issue of extraterritorial obligations is not a new one for human rights, the human rights system. We've seen some of these ideas being developed in the economic and social rights space. Business and human rights, advocates working on issues to do with the war on terror. All of these areas are pushing the envelope on our understanding of extraterritoriality. But I also think that the work I found particularly helpful in this respect is the work of James Hathaway and some of his colleagues. And in a very compelling 2015 Columbia Journal article that he wrote, he charted how our sort of evolving, more expansive thinking on jurisdiction might open up space for more effective engagement with governments who are deploying externalization practices, even in the absence of territorial control. So for example, where a state exercises control over persons outside of its territory, as well as in some circumstances where a state exercises public powers outside of its territory pursuant to a treaty or other obligation. And he points to the Hirsi case, where a grand chamber of the European Court of Human Rights ruled that Italy had jurisdiction over migrants who were turned back on the high seas under the auspices of its cooperation agreement with Libya. The court observed that the events took place entirely on board Italian ships crewed exclusively by Italian military personnel, and that the migrants were under the continuous and exclusive control of the Italian authorities from the moment they boarded the ship until the moment they were handed over to the Libyan authorities. Given the lack of protection for refugees in Libya and the risk of persecution for the applicants if they were returned to their home countries of Eritrea and Somalia, Italy was in breach of its obligations under the principle of non-refoulement. Similarly, the Committee Against Torture in the Marine One case considered a case where Spain had exercised jurisdiction in rescuing 369 migrants in waters off the West African coast. After boarding Marine One to provide emergency health care, Spanish authorities towed the vessel to a Mauritanian port where the passengers were disembarked. Most of them were returned home. 23 people wanted to remain. They resisted repatriation and they stayed at a sort of fishing plant under Spanish authority in this Mauritanian port. And in those months that they were there, alleged that their rights had been violated. And the Committee Against Torture there also concluded that Spain had exercised jurisdiction both during the interception and throughout the detention in Mauritania, because they had stayed effectively in control of the space where these migrants were being held. And it talks about both direct, the Committee Against Torture talked about both direct and indirect de facto or de jure control over persons in detention. And I think that reference to indirect control also opens up some space for some creative lawyering to tackle different types of extraterritorial policy. So, I'm sure you've all, as LLM students, have looked at the Al-Skaini case about, the exercise of official powers under agreement with the host state, and how that can also implicate the obligations of, the destination, the sending state. In that case, we were talking about the UK, its forces in Iraq exercising official sort of policing functions, and were held, to have exercised, to have had jurisdiction and violated, European Convention on Human Rights obligations in that case. So I think, there is space to think in a creative way about jurisdiction. There's space to think about shared responsibility. And there's also guidance from the International Law Commission about, even in cases where there is no jurisdiction as such, this idea of aiding and assisting another state in the commission of an internationally wrongful act. It's sort of there for the taking, and I'm just looking for some creative young lawyers who might be interested in taking up some of these cases. Of course, every time I suggest this to lawyers that I work with, they're like, stick to advocacy, stick to advocacy. But I just think that we need to start joining up the legal dots to hold states accountable for some of this issue. We also need good and robust data, obviously, to link, what states are doing with the impact on migrant health and migrant deaths. We see a lot of excellent work by human rights organizations. A lot of it still is in the realm of narrative accounts. We don't see that kind of really robust data, I think, that would probably be needed to anchor some of these claims. That was part of the reason why I went to a public health school and why I work with public health researchers. We have some work underway right now in Mexico that I mentioned with Jesuit refugee services, attempting to follow over time a group of migrants who are trying to access the United States to track what is happening to mortality rates over time, what is happening to their physical health, what is happening to their mental health. We see other interesting initiatives, to sort of look at death registries, groups that have tried to look at death registries in Southern European towns and municipalities, looking at records of morgues and burial studies to try and understand how many migrants are dying through these irregular border crossings. And this work took place in Greece. But we really need researchers of different disciplines to adapt their strategies accordingly. And without, I fear, a more systematic approach, families of asylum seekers and migrants are left without ever really knowing what happened to their loved ones. And critically, I think states are not held accountable for the sort of foreseeable deaths that their policies result in. And I really think that we need to take the issue of missing migrants, as seriously as we take the issue of people who are missing in war. And when you think about all the efforts that go through the ICRC and other organizations into telling loved ones what happened to folks who disappeared or who went missing in war. And I think the human anguish that accompanies these stories is no less real. So I think in conclusion, I would say, underpinning the refugee rights regime, at least as it was conceptualized in 1951, was the idea of shared responsibility and really a general obligation to, assist refugee receiving countries through international cooperation. And this idea was foundational also to the Global Compact on Refugees, which is an international agreement that was concluded to much fanfare in 2018, and it was intended to sort of revive and resuscitate, state commitments in this area. But I think the reality of what we are seeing really falls far short of that rhetoric. And I think externalized migration controls not only really represent the very antithesis of responsibility sharing, But the way they are being practiced by the UK, by the US, by others, poses a really existential threat, not only, of course, to the migrants and the asylum seekers of today, but I think that these practices are threatening the very foundations of the refugee protection regime itself for our tomorrow. And so I think we ignore them at our own peril.
Thank you. So, on that very hopeful note,
Sorry.
I think the floor should be open. There are lots of themes to pick up from that. I'll flag a few. One is the clandestination of forced migration internationally. The second is the replacement of the regime of entitlement, which asylum is supposed to represent, with a discretionary regime. For those who are interested in, who are doing law and development, which we're going to be confronting soon, the redefinition of development assistance and what it means, not just in its content, but also in its strategic functions. And the endangerment of the foundational character of refoulement in refugee law. And I don't want to talk about, for those who are into movies, there's a new meaning to Hotel Rwanda. But really, the end is, Professor Zad ends with a very fulsome call to researchers of different disciplines. That sounds like a call made for Fletcher School. Because we represent here different disciplines in a joint enterprise, but also different nationalities as well. And the, Fletcher School is a mini United Nations in class, not in summit. So there we go. Please. Yes, Virendra.
Ma'am, we lawyers in India, large community were disturbed when the Rohingya matter came up to the Supreme Court, and Supreme Court said that this is a moral executive decision. Now, I'm sure this would have reverberated right up to the UN, and they would have tried to cajole.
Sorry, does everyone here know about the Rohingya?
Oh, no, I didn't know.
Okay, it looks like I see lots of heads nodding. So
I cannot discuss this.
No. I just wanted, I wanted to invite you actually to background the Rohingya.
Okay, you want me to do that?
Just a little bit.
Yeah, okay, so this is a large community from Burma. I will not touch the religious part, which migrated from Burma and they moved to India, being the neighboring state. Of course, as ma'am said, most of these people, they migrate to middle-income countries, and India was a middle-income country where they mostly migrated. Now, when they reached India, India was not very, under Article 14, they should, policy of non-refoulement, they should have accepted, but they refused to accept. Matter reached the highest court, Supreme Court, and they said, well, it's an executive decision. Of course, that kind of shattered we lawyers, we didn't expect that from Supreme Court. India is largely a more tolerant country. So it would have gone up to UN also, and UN would have tried to do something to convince India that we have an active opposition in parliament to accept them. So really, what would have happened and why even finally India could not be cajoled to accept them and have them in a part, maybe they could even, I don't know if they have a policy to, like you were saying, development assistance. So why is it that finally they could not find a place in a country like India? We normally are considering India as a very tolerant country, but they were not accepted.
No, I mean, I think this is what makes this area of work so both interesting but complicated. We confront the limitations of the international human rights regime, right? At the end of the day, you've exhausted all the legal avenues. None of them have been helpful to you in reversing this decision. And the reality is a political climate that does not accommodate this particular group. And what do we do about that? I mean, I don't think the answer is, law has nothing to add. I think in this particular instance, it provides a framework of principle, policy, and frankly, the fact that we have international mechanisms at least provides, some alternative when you have a domestic Supreme Court that is not proving helpful on your issue. But I do think that, for a country like India, which looks at, countries like the United States, the European Union, it makes it that much hard to make the argument that they should open their doors when they see, so many negative examples being practiced around the world. So I don't have an answer for you. I wish I knew what to do in those situations. I do think we've been neglectful in not building up domestic constituencies that argue in favor for the importance of asylum, for the importance of upholding these just basic protections for people. I think that's the long-term work of human rights that still needs to be done in the refugee space and other spaces as well. But I also think that part of the response needs to be ensuring that all states are upholding these, and not just the letter of the law, but the spirit of it as well. So I wish I knew more. I wish I had a silver bullet, but I don't. Thank you for your question.
Yeah. Other question? Not yet. Yeah. Yes, Alison.
Hello, I'm Allison. I'm a MALD student here. I have had the great pleasure of sitting in on some CBP meetings with the organization called the Smart Border Coalition, and a big push with all of them was creating or changing the narrative of the border to something that's focused on technological advancement, the great trade that comes back and forth and the flows of people for work and nothing on migration. And I'll also note that the only people represented in these meetings were always business persons, some politicians, and then of course like security personnel from CBP. And I'm curious what you think this changing narrative could mean for the migrant persons coming across the border, trying to, they're kind of invisibilized by, this new tech narrative.
I think that's really interesting. And I'm a bit conflicted about it, I have to say. I think that the narrative is an important one to get out there, because the reality is migration is fueling the economies of the United States and much of Western Europe, actually. The reality is, states, of course, have sovereign discretion to exercise their migration control however they wish, and they want to cherry pick who they want to come in. So if you take the UK right now, the UK National Health Service is floating on migrant labor. Doctors and nurses who are trained mostly in sub-Saharan Africa and the Middle East, that they are relentlessly poaching. I can say this, my brother-in-law was the last of 2 working anesthetists in Lebanon, which is a country that is on the verge of collapse. And he's now working in Wales, senior consultant level. He got a visa, but my 85-year-old mother didn't get a visa to go to the UK. So it tells you about how states are very aware of the economic benefit of migration. And that's why you see corporations and business administration to have a much more progressive approach to the border. Having said that, I am concerned that as we recast this narrative to one that is more focused on economics, that we lose sight of the fact that there is a fundamental moral and ethical obligation to help people who are fleeing conflict and persecution. Now we can talk about how you define conflict and persecution is very clearly defined, but we talk about climate change and those other things that are at the margins these days. But I see it in what we're doing today on the US southern border. The people who are enabled to come in are those who are able to access the app, make the appointment, show that they have financial or fiscal sponsor in the United States. Why does that matter? If we're screening for protection and asylum seekers, the fact that someone has a fiscal sponsor in the United States shouldn't matter. And what I worry about, and I worry a lot about many different things, that's why I have so much gray hair. But I think, you know, I can see this happening. I can see a narrative focused on economic benefit eventually being used as a way in which to screen out people who are absolutely deserving of their right to claim asylum, but may not have an immediate contribution to make to the economy, or may not have fiscal sponsors, financial sponsors here in the United States. And that really troubles me. And I can say this because I wrote about it. I could see where the anti-smuggling and trafficking work would end up back in the early 2000s when the Convention on Transnational Crime was adopted in record time, 5 years for an international treaty. How long does it take for a human rights treaty? Glacial, 5 years. And you could see where this would end up. And everyone's like, no, this is protection. It's not protection. And I think we have to be very careful as scholars, as advocates, that we don't inadvertently, in the name of a short-term gain, undermine the long-term edifice that our rights frameworks are built on. Very long-winded, sorry, but it's a great question.
Well, while there's a lot of thinking going on around the room, I hear the thinking going on. I'm wondering, just following up on Virendra's point, because there is push here and there is pull. And Virendra's point is about the pull in India, where the Rohingya have come to. But the push in Burma, who's addressing it and how is that being addressed? The Gambia has sued the Rakhine state before the International Court of Justice under impetus from the Organization for Islamic Conference, arguing that there is actually genocide directed, or certainly acts of genocide directed at the Rohingya. And now, if countries are willing to externalize border controls for these purposes, what could they possibly do to address the underlying causes that give rise, the push factors that give rise to these issues, so that we don't end up building Hotel Rwanda in lots of countries?
I mean, I think you know, this is why I think we need a comprehensive approach. I think we need all of the above. I think we need to hold states accountable for their human rights violations domestically, using whatever creative lawyering we can do. We need to build constituencies that can argue for asylum to remain a valid, you know, sort of option for people in countries that they flee to. We need to, you know, think about how international organizations you know, serve the bedrock of law that they're supposed to be accountable to, as opposed to the individual interests of their donor states. I think we need strategies that really are all of the above. And my worry is that, you know, we don't, I don't know whether there's just not enough sort of lawyers and advocates working in this space, or whether it's the volume of what we're facing. But I do think we need joined up thinking in this space, because I think the accountability efforts you're talking about are part and parcel of ultimately arriving at a durable solution for people who are in exile. I mean, the issue of protracted displacement now lasts for, you know, an average of, is it 17, 18 years? You know, many of these people find themselves in countries where integration is not acceptable or an option. They don't have full-fledged rights to integrate, so they end up living for many years in camps, lost generations. If we are to talk about durable solutions, those can only happen when you have accountability for the crimes that cause people to flee in the first place. And if you don't have that, all you're doing is storing up more displacement for the future. So it worries me, for example, when I look at the Syrian context. You know, obviously Syria and Turkey are grappling with a major earthquake at present. But you can see the drumbeat now as Turkey responds to the earthquake, has limited resources for even its host population, its own population. You can see the rapprochement that is happening between the Arab states and Syria, delegations visiting, the rapprochement between Saudi Arabia and Iran. It's only a matter of time before they start talking about the return of Syrians, probably the forced return of Syrians to Syria. And without a conversation on transitional justice ever being put on the table. And I just don't see how any return like that is going to be sustained. All it does is sort of promote a cycle of displacement and violence. I don't know if that answers your question.
That helps a lot. Yes, Faye, please. And then Dan.
Maybe we should give the students.
I'd
like to react and maybe add a few things or not from a European perspective. Because you talked a lot about joint responsibility, solidarity, and what can we do? And I'm afraid that, for example, the European perspective was actually not a success. Because in Europe, first we had this, this government procedures, which meant, okay, we'll have all these systems of these people entering, and they will stay at the first place of entrance, or they will be returned to the first place of entrance within Europe. And then with that, follow the EU-Turkey agreement, which you mentioned. Now, as things worked out, I mean, this was completely, it was both were a failure. Because I have to say that people entering, migrants entering Europe, first of all, enter through the sea. This was one difference we have maybe with the US, you see it. It's very interesting. I mean, it used to be through the streets of Gibraltar, that was finished a few years ago. It's coming back, but it happens through, of course, Greece and Italy, and you mentioned that. So, and this movement, these people who come are not coming to Greece and are not coming to Italy. They don't want to be in Greece. They want to be in the north. That's where, that's where they want to be. And locking them up in places where they don't want to be is also, for me, not a solution. If, we want to think in terms of, like you say, ethical or human rights oriented solutions. And of course, Greece and Italy have been condemned by the European courts many times, and rightfully so, for not, abiding by their obligations. We have to keep this in mind, because now as things are, like you say, turning economic, it's becoming perhaps more obvious to other parts of the world that this was the real, if you talk to, I had the opportunity to people who were coming through or were migrants, irregular migrants in Greece, they weren't coming, they wanted to leave and go to Germany, Denmark, Norway. It's absolutely, So I'm trying to say, and then of course, if they went there, Denmark or no, said, no, this is not your country of first, and they would be sent back, which was for them inhumane treatment. And I was in one case of the Human Rights Committee where, and some other cases not involving Greece, I couldn't be in cases involving Greece, where it was, for example, returned from Denmark to Bulgaria, and if the asylum procedures had been held, etc. And where the person did not want, was saying that if I go to Bulgaria, it will be cruel and inhumane treatment because Bulgaria is not an economically developed country. So those are also some things that are interesting. Yeah. On extraterritoriality, you're right, it was very interesting to hear you. I think human rights courts are starting to look at this issue a bit more carefully, less diplomatically than the European Court did perhaps initially, and accepting that there is some extraterritorial jurisdiction of states with these, either the pushbacks or these agreements, which I'm not sure about the international legality of such agreements. That's another question. Thanks very much. It was very interesting.
Thank you. I share your sentiments about the sort of European arrangements and their failure, and the reality that so many of these migrants who are transiting through Greece and Italy have no intention to stay there. The failure of the burden sharing kind of idea that underpinned EU arrangements. But then I look at what happened with Ukraine. And Ukraine is a phenomenal affirmation of why a regional European system can work if you let it work. And I mean, really, if you wanted to model what reception should look like, the Ukrainian reception as well. I was involved in a conversation that the US State Department is got huge amounts of money on the table at the moment for researchers who want to work on trafficking. And people were asking the question, why isn't there trafficking with the Ukrainians? And you know why there isn't trafficking? I mean, this is my I will
Everyone not let them, everyone.
they were given access to, social protection. They were given access to bank accounts. They were given, everything was put in place so that thankfully the danger that everyone was worried about initially, that trafficking would be rife, didn't materialize. And it was a fundamental affirmation of the fact that responsibility sharing can work if there's the political will behind it. So I don't know where that leaves us. I mean, truly it's a conundrum, because I agree with you. Up until that point, it had been a complete failure.
And even now in Greece and Italy and the southern European states, the reception of Ukrainians is completely different from, the other examples we had.
There are three hands I'd like to field in succession, and then we'll revert. Diana from Mexico. There is Excellence, who is a diplomat from Sweden, and I think it's important to hear that perspective. And I will insist on inviting Eb Korir, who comes from the country with the largest refugee camp, probably in the world, in Kenya, to offer an insight, and then we'll return it.
Yeah, so I was thinking a lot about my question because I'm working with Professor Chile on my capstone, and I'm looking at how the Convention on the Rights of the Child can create an additional source of protection for child migrants. And as I'm working through it, I'm not a lawyer myself.
Yeah.
So, so as I'm looking through it, I had a lot of questions, I guess, and why is this instrument not being utilized when making determinations on child status and protection related to migration? I think a lot of what I found right now is that a lot of the non-refoulement obligations are usually through court decisions like the European Court are attached to the ICCPR and the Economic and Social Cultural Rights treaties. But a lot of those rights that are putting emphasis on the right to life, the right to adequate healthcare and a reasonable standard of living are also included within the Convention of the Rights of the Child. And within the Convention, obviously, Article 3 it's calling for the assessment of the best interest of the child in the light of those rights. So as I'm exploring the literature and seeing what's out there, it seems like the connection of this obligation is not being directly used and tied into it. And I'm not sure why that is. In addition to that, I'm looking at state practices also. I'm from Mexico. And in the region, child migration has acquired a little bit more of attention. It's more of a phenomenon now than it was before. And the systems have been built to kind of conduct assessments, but yet there's a lot of discrepancies on how these assessments are made and what it means for children. So I wonder if you could offer like any insights on that.
Okay, Christoph, please.
Yes, thank you very much. Just as Chidi said, I'm from Sweden. We're working as a diplomat, and I just want to go back to the discussion we had about Ukraine, because I think it might be a little bit too early to call it a success. It was a success that the EU, after what happened in 2015, 2016, could actually make this happen and could kind of receive all those refugees. But what's going to happen in 1 or 2 or 3 years? Like in Sweden, for example, we have some social protection for refugees, but they are the ones that don't find a job are supposed to live on $7 per day. That's not the vote. So I think if we're going to call it a success, we have to wait a couple of years to see how long. So we're going to continue. What's going to happen with how the integration of those refugees in society? What's going to happen to the kind of member states that take in a proportionate share? For example, Poland and Romania. I think those are the questions that's going to be very important. So I think that it might be a little bit too early, with all due respect, to call it a success, but and I think that it would not benefit neither Ukrainians nor the kind of larger push for migration issues to this early call it success, because that could backfire later. So that, it was not a question, it was just connecting back to what we discussed earlier.
Ms. Sambo?
I was not prepared for this, but
Just that patient.
Well, there was a point about durable solutions and prolonged stay in camps, and
Yes.
that just reminded me of Dadaab, really.
yeah, because I think we have a situation of permanent refugees.
Exactly.
Have never been integrated in that refugee status. They've been there for, I think, over 30 years. now.
Generation,
Yeah.
more than one generation.
Yeah, and I think for me, what I know of the few things I know about the refugee camp is that the government has politicized it and instrumentalized it. There was talk during COVID that when the government wanted loans, or every time the government wants loan, then they start talking about repatriation, we need to repatriate the refugees. And we even saw this talk when Kenya had a case with Somalia at the International Court of Justice. And the hearing was coming up and Kenya could not opt out. I think Kenya was trying to push Somalia to have an out-of-court settlement. So they started talking about the refugee camp, or we will send back, because Dadaab is made up of majorly Somalis. So the government said we will send back Somalis back to Somalia. And then there was, I think in 2017, an issue that arose on security because of terrorism in East Africa, the Al-Shabaab that maneuver around between Kenya and Somalia. And I am not sure whether this was politicized, but there was a discussion on security and whether the refugees could be used, could be radicalized and pose a security threat. So I think those are the issues that I have seen arise around Dadaab. And I think there was a tripartite agreement between Somalia, Kenya, and the UN on repatriation. I don't know how that is going, but Kenya has been saying that the timelines that were given are overdue, and they call that every time they want to politicize an issue, they'll talk about the agreement. So,
Well, so final words.
Final words. I mean, these are very rich questions. Each one of them deserves more than a final word. But maybe if I could begin with Ukraine. I mean, I think you're right. It's too early to call it a success. It is a success, I think, in the sense that a mass influx that would have challenged any set of countries was managed, relatively smoothly. And the ability, I think, of the various countries involved in receiving Ukrainians to basically say, we're going to activate this temporary protection idea, we're going to use it, that's where the kind of regional infrastructure really helped for that kind of speedy, relatively uniform response that enabled people to move through relatively quickly to places where they could at least settle for an interim period. I agree with you, the jury is out on the long term. And what we know from every other single situation is that host communities, their tolerance, ebbs and flows over time. That's certainly something that history has taught us we should expect with Ukraine. So I think you're right, the jury's out. Very much depends on what happens with the war. I think it's highly optimistic to think there's going to be a speedy return. And of course, the longer people stay in exile, the more roots they put down, the less likely they are to want to go back. So there's a sort of built-in transverse relationship that I think we should just be aware of. But you're right, the jury's out. it just, for me, feels like we shouldn't toss out regionalizing the response in the way that I think was helpful in this particular instance. It shows what's possible. I think, on the Convention on the Rights of the Child, it's a really interesting question. I don't know why it isn't used more. I know it's certainly, some of the groups that have been strongest in the United States advocating for unaccompanied minors, child minors, especially when the Trump administration was separating children and families, drew on every single source of international law to kind of support their argument. The US has a strange relationship with the Convention on the Rights of the Child, but generally the entry point of using children has always been an effective one in advocacy. Use children in a way as a way of making broader points about the importance of protection. So I think you'll find that the groups that work on children, like KIND and others in the United States, are using those frameworks, maybe not exclusively, but in tandem with others. I think one thing that, there are 2 points that you made. One is you mentioned the work in Mexico to sort of build capacity to receive child migrants. And I think it's really important as scholars, as advocates, that we talk with our counterparts on the Mexican side about what is and what is not possible for a country like Mexico. As the US pushes more and more of the migrants who would ordinarily come to the United States, into a Mexican health system, into a Mexican asylum system, into a Mexican social protection system, we really should have a comprehensive approach to our advocacy. I mean, at a minimum, Mexican, advocates should be arming government with the arguments they need to sustain. We need these resources, we need this infrastructure, we need X, Y, and Z, in order to be able to deliver on rights protections that the Mexican state is now taking on. And it's only through working with these grassroots and civil society groups that we will really get a true picture of what's happening in Mexico in terms of receiving these migrants or having them wait for these prolonged periods of time in Mexico. So I think it's an opportunity for building up capacity in Mexico. And if these policies continue, it's absolutely imperative that the advocacy happening on both sides of the border proceed in tandem, whatever that ends up looking like. The final thing I want to say on kids is I think we need to be really mindful. And if I ever have a spare 2 minutes, I want to start looking at a particular issue that I see bubbling up, which is the suggestion that adolescents, particularly adolescent boys, are not children for the purposes of migration. This questioning of that age group of the 15 to 18-year-old age group, the sort of acceptance that we can have very intrusive medical examinations of them to sort of figure out whether or not they are children. I think this is something that we need to be really cognizant of, we see it in different ways, but it's particularly impacting young men, young boys coming from sub-Saharan Africa. You see it on the southern border, and you see it also in the MENA region, actually, with youths that are accused of engaging in violent extremism. This questioning of whether that 18 figure, that age group, is an absolute. And one day, if I have a smart research assistant who wants to work with me on this, I would love to just do a little bit of surveying to see how widespread is this, because I think that might be coming down the pike, and it's something that we should be ready and aware of. And then finally, on durable solutions, I mean, Kenya, Uganda, the countries of sub-Saharan Africa have shown the way in terms of hospitality, frankly, hosting millions of refugees over decades. And when you look at how a country like Jordan has instrumentalized their refugee populations, on the one hand, refugees have rights. On the other hand, host communities, host governments have also a right to demand that countries of the global north actually absolutely support them in a meaningful way to sustain these populations. And I think we need a much more sophisticated conversation about what that support is supposed to go for. It shouldn't just be sustenance. It shouldn't be just survival. Jordan has used its hosting of Syrian refugees to negotiate preferential trade agreements. It's used the Europeans, I think, to negotiate sort of preferential travel. There are ways in which I think it's perfectly legitimate for host governments to ask for things that will benefit their population in the long run. I guess the only thing that we need to just be aware of is that refugees have rights too, and they have a right, once they've been there for several decades, to rebuild their lives, right? To have access to those things. So it's good old-fashioned aid conditionality, but with rights at the center, right? And with centering the long-term interests of refugees, which I think is absolutely critical for being able to navigate these conversations about humanitarian aid and development aid.
Thank you ever so much. This is ranged quite far afield, but I like the fact that we're ending on the note of a comprehensive approach to the subject matter. And in many ways, that's what the framework and the framing of international migration gives us. Because when you look, particularly returning to the environment of graduate studies with a focus on LLM studies, in particular studies for an LLM qualification. International migration enables us to look at the framework of international mechanisms in a fairly comprehensive manner. Because every mechanism somehow does offer some framework of remedies towards migration-related challenges and violations, whether it is, and you see that in whether it is the Committee Against Torture, for instance, letting us know what quasi-state entities are like, and enhancing the notion of who could be duty bearers in international law, or whether it is regional courts and tribunals grappling with the scope of extraterritoriality and of the future of non-refoulement, or the International Court of Justice now being saddled with questions about the protection of the Rohingya, or the Committee on Economic, Social, and Cultural Rights having to figure out the entitlements of people in forced displacement. You're seeing that a dispersal of responsibility and real burden sharing, certainly not in the traditional migration sense, but burden sharing amongst the mechanisms of international law. The only entity, I presume, not challenged with these issues, John, you'll be happy to know, is the Tribunal of the Law of the Sea. But who knows, we may be getting there soon.
Duty to rescue.
But really, this says we all have to be, we're all exercised by this and have to, at different levels, not just at the advocacy level or the level of jurisprudence, but also at the level of policy, and how those get redesigned and get managed. And that's really the note on which I'd like to suggest we bring this to a close and hope the conversations continue and the search continues, both for ideas here and when you leave here for policies for how to address them. Thank you very much. And once again, please join me. LLM students, next stop is the capstone retreat the month after next. So pretty much exactly 2 months from now.
Gotta finish that capstone. I can make those.